during that ex parte hearing, meeting, whatever you want to call it, during that ex parte meeting, there was something very important, very damning, and could be a huge win for the defense. And what was that one thing that happened? Little Woody said a phrase when he was in that ex parte meeting that could change everything for Young Thug. Little Woody said, "I did these crimes." Recently, some controversy in the last few months going on between her trying to run this case against Donald Trump. There's a lot there. We're not going to get into the details of that. So Fani Willis has been in the news pretty often here for the past few months. Now, she has apparently and obviously been watching what's going on with this YSL RICO case, because this is going to be the biggest case in her career, in her history so far, right? So she's been keeping an eye on it, watching it. And she recently heard that Brian Steele was trying to get her people off of the case. Well, as we know, Brian Steele filed a motion to get ADA Love and ADA Hilton out of there. And Fani Willis did not like that. She's ready to throw some shots. And she filed this response to what Brian Steele, aka Young Thug, had to say about ADA Hilton and Miss Love. So we're going to get into it, see what Fani Willis has to say, because they're bringing the big dogs in now. And it's about to get ugly, in my opinion. All right, y'all check this one out. This is the state of Georgia versus Young Thug, aka Jeffrey Williams, aka Brian Steele, his representation. And this is a letter to Judge Whitaker. Check it out. State's response to defendant's motion to disqualify lead prosecutors. The state of Georgia, by and through Fani T. Willis. Big Mama's here. District Attorney of the Atlanta Judicial Circuit hereby responds in opposition to defendant Young Thug's motion to disqualify lead prosecutors Chief Deputy District Attorney Adrian Love, CDDA Love, as she's more formally known, and Deputy District Attorney Simone Hilton, DDA, filed on July 10th, 2024 and on July 18th, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendants cite no facts and no law that authorize this honorable court to disqualify either CDDA, Love, or, okay, we're not doing this, Love and Hilton. All right. Okay. We get it. They've got some cool titles. Let's just keep it moving. Accordingly, the state respectfully moves the honorable court to deny defendant's motion to disqualify the lead prosecutors. Okay, so is she correct that Brian Steele did not cite any facts and law? No.
Stop the cap.
We're already at a bad start here. I mean, if you look at everything that was done in the ex parte meeting, that alone, as we mentioned in the last videos and live stream, is enough fact to see that what they were doing wasn't right. So I don't know what Fani's talking about, but we'll give her a chance to give a proper response, and then we'll break it down here shortly. Accordingly, the state respectfully moves this honorable court to deny defendant's motion to disqualify the lead prosecutors. In support of this response in opposition to defendant's motion to disqualify, the state shows this honorable court the following: where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to the defendant. The laws of Georgia and the facts of this case mandate the court's denial of the defendant's motion to disqualify. In support of his motion to disqualify the lead prosecutors, defendants asserts that lawyer Love and lawyer Hilton have made themselves critical witnesses in this case. When Love engaged in text messages with a witness, and when Love and Hilton participated in a hearing in chambers with the witness and his lawyer regarding contempt proceedings against the witness. Okay, those are facts. So again, we're already on the bad start. The defendant stated no facts. That is a fact that these things happen. So Fani, you're already, come on now. Now she's saying those are facts that can't disqualify them. Well, we'll see what she says moving on, but we're already off to a bad start. Defendants cite no legal authority in support of this position. Defendants, however, bears the heavy burden of proving that disqualification of the lead prosecutors in this case is warranted. Okay, how about Miss Hilton giving Lil Woody false information, wrong information in an ex parte meeting? Y'all know what side I'm on when it comes to the fairness of this case so far, and it's not the district attorney's office, but we'll keep going. Instructing that it is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted. Defendant does not even attempt to meet this burden. Instead, he rests his pleadings on legally and factually unsupported assertions. Wow. The hearing in chambers was proper. Here we go again. So now, not only do we have Fani Willis saying that this hearing in chambers without the defense there was fine because it was about the contempt that Lil Woody was being held under. But we also had, if y'all remember going back, we also had another judge that said, okay, we get that they had the ex parte meeting. I don't see anything wrong with the ex parte meeting. I don't see anything wrong with what Judge Glanville did. But because this is a bad look and we want people to trust the judicial system, we're just going to go ahead and get Judge Glanville out of here. Which was wild, in my opinion. But it seems like they're all pretty loyal to Judge Glanville and Hilton in love and want to make sure that they're taken care of because what they're saying just doesn't make sense at all. Defendants asserts without support that Love and Hilton are disqualified as prosecutors in this case because they attended a hearing in chambers that he believes himself entitled to have attended. That's weirdly phrased, but we'll keep going. Defendants argue that the lead prosecutors in attendance at the hearing are disqualified under Georgia Rule of Professional Conduct 3.7 from further prosecuting the case because defendants now need to examine them about the hearing and what took place. Basically, he wants to call them as witnesses. Defendant's argument is not grounded in law. The hearing in chambers was about an ongoing contempt proceeding against a witness who leaving out information here. He's not just a witness. He is a sworn witness. This dude was on the stand. So let's not leave any information out here, District Attorney Willis. This was a sworn witness. This just wasn't some witness they were talking with before he went to the stand. He was sworn in. He was on the stand, and that matters. The hearing in chambers was about an ongoing contempt proceeding against a sworn, I'll add it in there, witness who upon motion of the state had been compelled to testify but refused to do so. We're aware. The hearing was proper. Nope. See King versus State, ruling where King had complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify in King's trial and confirming the use and derivative use immunity that would apply to that compelled testimony. The hearing appears to not have been a part of the proceedings against King. How is it not a part of the proceedings if he's a sworn? I don't understand. Again, I'm just the guy, y'all. Let me know in the comments if I'm just completely missing something. The Georgia Supreme Court pointedly recognized in King, and then they cite the actual pages here, under circumstances closely resembling those here, that while King might have preferred that a key witness not be ordered to testify truthfully in the trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order compelling the witness to testify in King's trial, or that would suggest that King's rights were the subject matter under consideration. Didn't Lil Woody tell them that he was going to lie, though? Where does that factor in here? On the contrary, the trial was obligated to consider whether the testimony was necessary to the public interest, a matter which King had no standing to address. And any alleged bias on the witness part was the proper subject of cross-examination, not grounds for denying the state's request for order. Okay, so they're saying they can ask about anything they want in cross-examination. Is what it looks like it's saying, holding that the credibility of the witness ordered to testify under 24-928 is a jury question. Likewise, Allen versus State, the Georgia Court of Appeals cited King in support of its holding that a defendant has no standing to contest the grant of use immunity to a witness. Under both King and Allen, the June 10th, 2024 in-chambers hearing was proper. I'm not seeing it. What? Yeah, you kind of lost me. This seems like two totally different circumstances. And was Mr. King a sworn witness? That's what I want to know too. We'll have to go back and look at this case. Under both King and Allen, okay, we read that part. We're good. CID, surely defendant does not expect that a proper hearing, which he had no standing to contest or to participate in, now somehow provides defendant the right to disqualification of the lead prosecutors who took part in the hearing. Such a position makes no sense. I disagree. Disqualification of the prosecutors who constitute an abuse of this honorable court's discretion, where other sources of evidence about what happened at the hearing are available to defendant and obviate any need of defendant for either prosecutor's testimony. So what she's trying to say there is everything you need is in the transcripts. So you wanted to know what happened in the meeting. Here's the transcripts. Now, the issue is if we get to cross-examination, which again, man, I really want this case. I really want this to be done. I'm going to be honest, just because it hasn't seemed fair for most of what we've been covering. But I do want to see cross-examination from Lil Woody, because Lil Woody, as y'all know, and we reviewed, he even went on an interview with his ex-lawyer, Caleb Bumpus, and said those transcripts aren't complete. Also, there's other issues, again, as we mentioned, that they lied in the in-chambers. They coerced Lil Woody using unfactual statements. I mean, there's just so much here that is wrong and legally wrong, even though we had another judge saying that, oh, it was okay, Judge Glanville did his part. Lil Woody is going to get them out of there. So if we don't do it now, Fani, Lil Woody, if he gets cross-examined by the defense, it's going to happen sooner or later. So why not just get him out of there? Because Lil Woody says that these transcripts were not complete. Then you're going to have to call them as witnesses. I don't get it. Even if the hearing had not been proper, an even bigger hurdle barring disqualification of the prosecutors is the availability to defendant of other sources of evidence of what happened during the hearing. With some expectations, Rule 33.7 of the Rules of Professional Conduct of the State Bar of Georgia provides that a lawyer shall not act as advocate at trial in which the lawyer is likely to be a necessary witness. However, the party moving for disqualification of a lawyer under Rule 3.7 has the burden of showing that the lawyer is likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact and that there is no other evidence available to prove those facts. The transcript's not enough. We read and we reviewed and we looked through the transcript, y'all. It's not complete by any means. So there's a lot of stuff missing. Even the way it starts is weird. There's parts where Lil Woody, he says, I did these crimes. What? And nobody says anything after that. They just kind of ignored him. It seems like there's a lot missing here in the conversation. So if the court reporter caught it, they didn't have anything to say after Lil Woody. Yeah, this is crazy. Defendant cannot meet that burden is what Fani Willis is saying. The hearing in chambers was taken down by the court reporter and transcribed. All parties now have the transcript of the hearing in chambers. The transcript clearly identifies those who were present, and that includes sheriff deputies, investigators from the district attorney's office, the witness currently on the stand, and the witnesses. I love how she said it here, but she didn't say it back when she was talking about them having the ex parte meeting. Anyway, the witness currently on the stand and the witness's attorney. Indeed, defendants will get to cross-examine the witness at issue himself. The practice of trial attorneys testifying is not approved by the courts except where made necessary by the circumstances of this case. All right. And we've got Timberlake versus State. The advocate as a witness possesses innumerable threats to the integrity and reliability of the judicial process. She also highlights courts have properly refused to permit a prosecutor to being called as a defense witness unless there is a compelling need. If Lil Woody says they're lying, wouldn't you need to get on the stand and say why you're not lying? We're not just going to look at the transcript and say, hey, Lil Woody, I said this, and this is what the transcript says, and now we're moving on. No, I want to get you on the stand, and I want to ask you, and I want to hear you say under oath that this is what happened. It's a mess, man. Trial courts are generally held to have discretion on whether to allow a party to call opposing counsel as a witness, on the view that attempting to call opposing counsel to establish some fact that can be readily proved in a different manner should be discouraged. To me, again, y'all, I'm not a lawyer. I'm just looking at this as a common sense, regular person. If Lil Woody says that the transcript isn't true, then we got to call them as witnesses. It's that simple. And again, Brian Steele, I hope you got, oh man, dang, we might get called into court. Because I think I'm one of the few people who actually did a review video on what Kayla said in her interview with Lil Woody. And those videos are gone now, except for this channel. So y'all might see one of these videos cited in some upcoming, oh man, dang. In some upcoming filings from Brian Steele, because Little Woody said, nope, those transcripts aren't complete. And the only place he said that was on Kayla's YouTube channel. Well, those videos are gone now. They're deleted, but we did review those videos, and I don't know if there's any other places that reviewed them. So I guess I need to go ahead and reach out to Brian Steele, figure out what we're going to do. Dang. Because when it gets to cross-examination, they might play this video and they might play that clip where we showed Little Woody shaking his head. Kayla said, Woody, do those transcripts look complete to you? Do they look like that's what happened in the ex parte meeting? Woody was like, dang. There is no compelling need for the lead prosecutors to testify, especially given that there are ample other sources of information to establish what occurred at the hearing chambers. Disqualification of prosecutors' love based on the exchange of text messages with the witness also would constitute an abuse of this honorable court's discretion where other sources of evidence about the text messages are available to the defendants and obviate any need by defendants of Love's testimony. Basically, she doesn't need to testify. You guys have access to the text messages. With ample sources of evidence about text messages being available to defendant, most notably the witness himself, whom defendant already has examined at trial. Defendant asserts that the text messages also require his examination of Love. And it says defendant's motion contains no reference to his examination at trial of the witness or the text messages introduced at trial through the witness at state's exhibit such and such and such. We'll keep it moving. The law contradicts defendant's assertion. See Schaaf v. State. Noting that speculation as to the content of an opposing counsel's testimony could not support a disqualification order. We'll have to see what happens with this witness list too, because if Judge Whitaker says, yeah, you can call them as witnesses, then this entire argument that Fani is making is going to fall flat in the first place. So we'll see what happens there. That the trial court abused its discretion when it disqualified trial counsel on the basis that the trial counsel's testimony was necessary, where the victim made a statement in his what? Come on, DA. Where the victim made a statement in his presence, but the statement had also been overheard by both the victim's mother and by trial counsel's assistant, who could testify on the circumstances surrounding the child's statement. Wait, oh, okay. They're going back and saying this is what happened in Schaaf v. State. Gotcha. All right, that was a little confusing. We made it through. Although the Schaaf court agreed with the trial court's concern that trial counsel's testimony would be relevant to the jury for determining weight and credibility to assign the child's videotaped recantation and possibly the preferred method, the Schaaf court ultimately concluded that testimony was not necessary to prove any fact related to the video or the circumstances surrounding the video. And I don't know how to pronounce those two names. The court explained that such speculation as to the content of the opposing counsel's testimony could not support a disqualification order. Otherwise, any party could successfully move to disqualify an opposing attorney by simply averring that the opposing counsel might possess information that is damaging to the attorney-client's case, therefore that the attorney is likely to be a necessary witness in the moving party's case. To approve of such a tactic would be opening the door to blatant misuse of the rule that already had a great potential for abuse. I agree with this. Basically, this is saying is that in the case of Lil Woody and ADA Hilton, right? She was allowed to have contact, to talk with him, to text him, to call him, because it's their witness. Now, the issue is, when did this take place? What did Lil Woody request? Did he have representation, even though he's a witness? If he had representation and the representation wasn't there, is that an issue? So I have to give Fani this one in the case that if you're going to go down this road, then basically any contact that an attorney has with a witness is going to be an issue. And that's a tough one to go down. But there are some extenuating circumstances in this case because there is an ex parte meeting. Judge Glanville already got kicked out because whether it's because the ex parte meeting was wrong or that it just looked bad, Judge Krause had to get him out of there because he didn't do the right thing, which is clear. So it's not, I get what she's saying, but it's still not the same thing. Defendants proffer no information he seeks to gain from Love that he cannot quite readily get, has already gotten from another source. Disqualification of the lead prosecutor under these circumstances would constitute an abuse of this honorable court's discretion. So with that being said, what I could probably see happening, especially now that he's off the case or that he's not ruling in this case, is that Judge Glanville is going to be the key witness when it comes to calling him up there, because he was in the meeting the whole time. ADA Love, she was in the meeting earlier and then she left and then she handed things over to Hilton. So we got to give Fani points on this one. I think she might actually have a good case. And if they need to call a witness, they can just call Judge Glanville. And looking at it from the prosecution side, I can see that. Y'all have to let me know what you think. Defendant's reference to the former trial judge has no bearing on the defendant's motion to disqualify. Although it is not necessary for the present motion, Young Thug asserts that he wants to call as a witness Chief Judge who until recently presided over this trial. Okay, I guess she's going to get into it. The state submits the Chief Judge is not a necessary witness for the same reason the lead. Okay.
Stop the cap.
See, this Vanny, I tried to give you some grace here and then you just went and messed it up. How are you going to say Judge Glanville shouldn't be called as a witness either? That makes no sense. He held and started the whole thing and got kicked off the proceedings because of it. Come on now. Yeah, she got 1 point with me and then she just lost 10. I tried, Fani. I tried. Golly, man. Although it is not necessary for the present motion, Young Thug asserts that he wants to call as a witness the chief judge who until recently presided over the trial. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors are not necessary witnesses. Obviously, she's again trying to protect her people because Brian Steele gets up there, or Judge Glanville gets on the stand. Brian Steele's there and he's like, hey, yeah, what did ADA Hilton say? Or what did ADA Love say? What did they say here? What did they say there? You know what? I just want to call them, because there's so many things that they said, Your Honor, I want to call them as witnesses. It's going to be hard for Judge Glanville to talk around the fact that they said this and they said that when Brian Steele could just get them on the stand themselves. But Fani's trying to protect her people. I get it. Moreover, while at no point did the chief judge comment on the evidence before this jury, it appears defendant's primary purpose in calling the chief judge would be to ask him to do just that. Although defendant has not requested permission to do that yet, the state submits the court should deny such a request when and if it is made. There is no evidence to this is number 2. There is no evidence to authorize disqualification of the lead prosecutors under the two only generally recognized grounds for disqualification of a prosecutor in Georgia: conflict of interest and forensic misconduct. And defendant does not even purport to request relief on those grounds. Okay, we're getting more into the law part of it. Defendant does not allege, nor does there exist evidence in this case suggesting that their prosecutor in this case should be disqualified under the two only generally recognized grounds for disqualification of a prosecutor in Georgia. 1, an actual conflict of interest exists, or 2, a prosecutor has engaged in forensic misconduct. Those are the only 2 cases that they could be disqualified. Now, let's think about this for a second. An actual conflict of interest, I don't see that there either. A prosecutor has engaged in forensic misconduct. I mean, nothing that we're aware of can show that. So she might be right there as well. Let's see. It also says in McGlynn versus State, the Georgia Court of Appeals recognized that a trial court considering a defendant's motion to disqualify an elected district attorney or her staff based on the alleged misconduct must hold those who allege such misconduct to a high standard of proof. Well, excuse me. I mean, we've got a whole transcript, and that seems like a good bit of proof. Plus, you're going to get Lil Woody and Judge Glanville on the stand. I mean, maybe Judge Glanville. I think they'll get him up there. We'll see. Even assuming for the sake of argument that the allegations set forth in the defendant's motion were true, those allegations failed to meet the high standard required to disqualify 2 lead prosecutors from an ongoing and well-advanced criminal case in the middle of a trial. The extraordinary relief Young Thug seeks is simply unwarranted, and this motion should be denied without any further proceedings. Additionally, she says, the court should deny the defendant's motion as not being sufficiently particularized in violation of the court's standing scheduling order of criminal cases in Judge Whitaker's division. His motion does not specify with particularity any evidence that supports his desired relief. How? We've got the transcript. What is she talking about? At best, the defendant has merely cobbled together a broad and barely defined class of allegations to support his theory, but he has utterly failed to explain how such allegations would necessitate disqualification. I think Brian Steele did a very good job of explaining it. We reviewed it in a past video. Y'all can go watch that if you haven't watched it yet. Conclusion. For the reasons stated above, it would be an egregious abuse of this honorable court's discretion to disqualify Love and Hilton solely based on the de minimis Have to look that one up. Assertions advanced in defendant's motion, especially where there is no evidence of any ground authorizing either prosecutor's disqualification. The court should not abuse its discretion by disqualifying the prosecutors, especially where the June 10th hearing about which defendants incessantly complains, she bold and underlines that, was proper, and where there are available to defendants other sources of information about which he claims to need to examine Love and Hilton at trial. Defendants' efforts to forestall the conclusion of the longest trial in Georgia's history by seeking to disqualify the lead prosecutor should be immediately stopped. The Honorable Court should deny defendants' motions to disqualify the lead prosecutors in this case on the pleadings alone. Submitted this 26th of July, 2024, Fani T. Willis. Oh, sorry. I hit the wrong sound effect. Oh, man. Sorry about that. So y'all have to let me know what you think, especially this last part, which is interesting to me, because if Fani and Love and Hilton are running based on the fact that the defense didn't need to be there, they shouldn't have been there, because this was a separate matter. What is the issue? And I'm going to tell you guys what I think, and then you can share your thoughts. The issue for me is that during that ex parte meeting, whatever you want to call it, during that ex parte meeting, there was something very important, very damning, and could be a huge win for the defense. And what was that one thing that happened? Little Woody said a phrase when he was in that ex parte meeting that could change everything for Young Thug. Little Woody said, "I did these crimes." So again, if the defense was there and they heard Little Woody say, "I did these crimes," and he's talking about crimes that are being addressed in another hearing in the main case, is cross-examination enough? Why couldn't the defense have been there to ask further questions? To me, something's missing. Again, we've got a lot of lawyers in the community, a lot of attorneys. I could be way off. And y'all have to let me know what you think and discover yourself in the chat and in the comments as well.